It is now my great pleasure to introduce our guest speaker for this evening. He is a graduate of the University of Western Australia in Science and Law, and therefore a member of Convocation. He was admitted in 1972 and practiced as a barrister and solicitor in Western Australia until 1983, when he went to the Independent Bar. During this period, he was elected as a member of the Standing Committee of Convocation, now known as Convocation Council, and therefore had a role in the leadership of this esteemed organisation. However, not being content with this achievement at a relatively young age, he went in pursuit of even higher goals, and in November 1986 was appointed as a judge of the Federal Court of Australia, an office he held until his appointment as the Chief Justice of the High Court of Australia on the 1st of September 2008. From 1994 to 1998, he was the President of the Native Title Tribunal. In 2010, he was made a Companion in the Order of Australia and a Fellow of the Academy of Social Sciences in Australia. He is a founding Fellow of the Australian Academy of Law, a member of the American Law Institute, an honorary life member of the Australasian Law Teachers Association and the Australasian Institute of Judicial Administration. Since 2016, he's been an adjunct professor at the Law School at the University of Western Australia, and following his recent retirement from the High Court on the 29th of January this year, he has indicated he is looking forward to being able to devote more time to UWA. Tonight, he will address the topic, Convocation and the University as a Community of Scholars. Please welcome our guest speaker this evening, the former Chief Justice of Australia, the Honourable Robert Fench, AC, Sit WA.
Thank you, Warren, and thank you for your service to Convocation, and congratulations to Doug and to Joan, who I think first persuaded me to come and speak, or as she put it in her emails, kiss the Blarney Stone on St Patrick's Day. There were those who were not so optimistic about this presentation. I bumped into one of your members a little while ago, and he said, "I see you speaking at the ordinary meeting. How are you going to keep us awake?" This will be a challenge. I want to say something about history and change in relation to the governance of this university, and in doing so, to draw upon apposite observations in relation to the law and legal institutions. There's a tension between historical concepts of the university as a community of scholars and its capacity to respond effectively to the practical economic pressures and other societal demands which bear upon it today, and of some of which the Vice-Chancellor has spoken in her report setting out the university's vision for the immediate future. And in that context, I also want to say something about the history and functions of Convocation. My contribution to these topics as a judge has been a little bit ambivalent. In 2001, I was part of a full court of the Federal Court of Australia, which heard a case called Quickendon and O'Connor. Terry Quickendon, who died in July 2005, was a long-serving lecturer and researcher in medical chemistry at this university. He was also an elected academic staff member on the University Senate, fondly remembered by generations of medical students under the sobriquet of Quickie. In fact, the West Australian Medical Student Society created a Terry Ivan Quickendon Award for WAMSS Person of the Year, and the University of Western Australia Academic Staff Association made him the posthumous recipient of one of its centenary awards. With all of this, he was also a very keen litigant. In fact, in 1988, he sued the Federated Australian Staff Association over something to do with the application of the Dawkins reforms. And more significantly, in the late 1990s, he started proceedings in the High Court, which were sent down to the Federal Court, in which he argued that he should not be bound by a certified agreement between the university and the National Tertiary Education Union, a certified agreement made under the Commonwealth Workplace Relations Act. And that Act made such agreements binding on people who were members of the union and people who weren't, and he was not a member of the union. He argued that the Act, and therefore the certified agreement, could only apply to trading or financial corporations, which is what the Act covered. And he said the university was not such a thing. The university argued, however, that it was a trading and financial corporation. And its argument was accepted at first instance by Justice Malcolm Lee and upheld on appeal by a full federal court of 3 judges, of whom I was one. Justice Lee, who was a graduate of the law school of this university, remarked rather dryly in his first judgment at first instance, "When the elements of constitutional law were taught in the Faculty of Law in the university 40 years ago, it would not have occurred to the dean of the faculty who delivered those lectures that the institution assisting students to seek wisdom was a trading corporation, much less that the university would assert that it was." The Quickendon decision reflected the constitutional character of the university 16 years ago, and there's no reason to suppose that that has changed. Its characterisation as a trading and financial corporation, which is based on what we call an activities test, reflects an aspect of the tension between the pressures on the university to derive commercial benefits from its activities and historical concepts of the university. What some of us might describe as part of the fossil record of that character can be found in Acts of Parliament, which establish a number of Australian universities and say, as this Universities Act says, that it consists of the Senate, the Convocation, the academic staff and graduates and undergraduate students. That formula has its ancestry in an Act of 1571 relating to Oxford University, so that the staff, the students and the alumni are not simply employees, customers and former customers of a corporation providing educational services for a fee. They are the university. And that equation evokes the idea, however imperfectly realised in historical practice, of a community of scholars, which extends, of course, to the alumni. The point came up more acutely in 2008 when I held in University of Western Australia in Grey, as a federal court judge, that absent an express agreement, the university did not automatically acquire intellectual property in inventions developed by members of its academic staff. UWA appealed the decision to a full court of the federal court, not trusting the judgment of one of its own graduates. The full court consisted of Justices Kevin Lindgren, Paul Finn and Annabel Bennett. Justice Lindgren in a former life had been a law professor at Newcastle University. Justice Finn had been a professor of law at the Australian National University. Justice Bennett, who also had a PhD in biochemistry, was for a time a pro-chancellor of the Australian National University. In fact, she's now the Chancellor of Bond University. Their judgment dismissing the appeal encapsulated the tensions between the historical roots of universities and the economic pressures to which they are subject today. They said of the university, "We accept that the university has not been immune from the forces, financial and otherwise, that are forcing changes in the character of the university sector in Australia. The university has engaged in commercial activities, as have done most, if not all universities. What is notable for present purposes is that there is nothing in the evidence to suggest that those commercial activities have displaced, either totally or if in part to what extent, the traditional function, public function, as an institution of higher education in favour of the pursuit of commercial purposes. Its function, in other words, was not limited to that of engaging academic staff for its own commercial purposes. Accordingly, we agree that on the evidence, Dr. Gray was not required to advance a commercial purpose of the university when selecting the research he would undertake." They went on to point out that a further distinctive feature of many, but not all universities, is that their academic staff are part of the membership that constitutes the corporation, a membership which is integral to their status and place in the university. And they said, to define the relationship of an academic staff member with a university simply in terms of a contract of employment is to ignore a distinctive dimension of that relationship. Critics of the decision said it embodied an anachronistic or 19th century view of universities. It would be my hope, however, that those who govern, manage, teach and research at universities, as well as those who study there, should not disappear into some dark night of managerial commodification, abandoning altogether the aspirational ideal of a community of scholars just because somebody formulated that ideal in the 19th century or even a lot earlier. In thinking about the tension between history and contemporary realities as they affect university governance, it may be helpful to reflect briefly upon an analogy to be taken from the law and legal institutions. It's not exactly a comfort zone, but it's a field in which I've been involved for a long time. The institutions and doctrines of the law, like universities, and the principles informing their governance, have emerged from a long, untidy, organic evolution. The famous American jurist Oliver Wendell Holmes once said in an oft-quoted passage, "The life of the law has not been logic, it's been experience. The law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if it contained only the axioms and corollaries of a book of mathematics." He was referring there to that common law of England, which is built up through centuries of judicial decisions, case by case, and which we inherited here in Australia, and which brought with it also institutions and understanding of institutional relationships between courts and parliaments and executives. In our case, of course, a history modified by the fact we adopted a written national constitution, borrowed in part from the United States, with a grafting on of the British tradition of responsible government. So those historical roots affect the ways in which, in law, we interpret our constitutions and the laws made under them. A former High Court Justice, Michael McHugh, said in a frequently quoted passage in 1994, "The true meaning of a legal text almost always depends on a background of concepts, principles, practices, facts, rights and duties which the authors of the text took for granted or understood without conscious advertence by reason of their common language or culture." And we can illustrate the general point by just looking at Section 3 of the University of Western Australia Act. There shall be, from henceforth, forever in the state of Western Australia, a university to be called the University of Western Australia, with such faculties as the statutes of the university may from time to time prescribe. That section established the University of Western Australia. Importantly, it established it as a university, and that's a generic word which carries with it a great deal of history. And history was plainly in the minds of the founders of the University of Western Australia. If you look at the opening passages of the report of the Royal Commission which led to its establishment in 1911, there were quotations from a number of notable sources on the purposes and benefits of universities. They were said to show how great a part a modern university plays in the development of the community. And one of them, a quote from the Spectator magazine, said, "The ground of truth and reason on which all law must rest is not only the business but the one supreme business of a university." And the commissioners concluded that the time had come for Western Australia to have that higher teaching in literature, science and art that a university alone can supply. So it's not necessary to be a crude originalist to understand that historical ideas of the nature and purposes of a university still infuse the word itself, and therefore the University of Western Australia Act in which it appears. So the model of governance which was adopted initially, some of you will be familiar with the history no doubt, was what they called a double-chambered arrangement, under which the Senate, the primary chamber, was to be the repository of the executive power and to initiate university statutes, and the secondary chamber, Convocation, was to form an electoral constituency for the election of 2/3 of the members of the Senate, with the balance being appointed by the state. And together they formed the government, the governing authority of the university. Now that term convocation, it's used in various ways. In America it seems to be used to describe graduation ceremonies. But the term convocation describes a calling together or assembly of people. And in the medieval Oxford University, its precursor was something called, grandly, the major congregation of regent and non-regent masters. It'd be a bit hard to market that today, I think. But it became referred to as convocation from about the 16th century on, and it was the legislative body, the parliament of the university, with a lesser body called the Congregation of Regents, which was like the chief administrative body. And it had the role of enacting and modifying laws and university statutes. It was the supreme governing body of Oxford University until the enactment of the Oxford University Act in 1854, which followed a Royal Commission, and after that its powers were diminished. It could not originate propositions. They had to come to it from the congregation, but it still had a general control over governance and could adopt or reject proposed statutes. Those powers diminished further over the 19th century and again throughout the later 19th century and in the 20th century. And from 1926, it retained only the power to elect the Chancellor, for some reason the Professor of Poetry, the public orator. Now, this university used to have a public orator. I don't know whether it still does. It was Mervyn Austin, I think. And the keeper of the archives, and to confer honorary degrees. It could still accept or reject legislative proposals from Convocation, but only under certain conditions and limitations. And following the Franks Commission in 1966, Convocation lost all control over the statutes of the university, though it could still elect the Chancellor and the Professor of Poetry. Now, the University of WA Act, as it was enacted, provided in Section 4 that the university should consist of a Senate, Convocation, graduate and undergraduate members, and it made the governing authority of the university the Senate and the Convocation. And Convocation at that stage consisted of members of the Senate, past and present, master and doctoral graduates who'd been out for more than 3 years, and people who contributed more than a certain amount of money per year for the last 2 years to the university through associations with which they were connected. The power to enact university statutes reposed in the Senate. Convocation couldn't originate them. In the case of a deadlock, you'd have to have a conference between the Senate and the warden, and if they couldn't agree, then the Senate could still pass the statutes on a 2/3 majority. In March 1941, Justice Wolfe of the Supreme Court of Western Australia undertook a royal commission into the administration of this university, and he made various recommendations about its reconstitution, reducing the number of persons elected by Convocation to 3. He noted that the constitutional structures of the Australian universities, when they'd been set up, had been patterned to some extent on the Scottish system of university government. But he considered that what he called the, quote, outlook, unquote, of Australian universities was more analogous to that of the modern English provincial institutions, and it was useful to look at those for guidance about constitutional arrangement. And one feature of those universities was that Convocation had a purely advisory function. Indeed, he had submissions before him that Convocation should be abolished. There are other submissions that should have no role in relation to statutes, and Convocation, not taking any backward position, submitted that its powers should be expanded to include the initiation of statutes. Justice Wolfe found a number of criticisms of Convocation to be, quote, only too true. They included difficulty in getting its statutory quorum of 25 and the unnecessary expense in printing and circulating statutes for consideration by it. He didn't think there was any purpose in retaining its powers in relation to proposed statutes and said, it's not much use allowing the graduate body a voice in the government of the institution if a minority, and a very small minority at that, is the only one sufficiently interested to elect representatives to the Senate and to consider proposed statutes. He actually pointed to a rather embarrassing incident which had occurred. The warden of Convocation was very disturbed about some of the things which had been said to the Royal Commission, so he called a kind of emergency general meeting, setting out a notice saying there was a threat to the very existence of Convocation and there was a need for it to prove that the allegations against it were wrong. And the notice concluded, I therefore urge you to show by attending the next meeting that you do not agree with the adverse opinions expressed. Now, Justice Wolfe himself received a copy of this notice, and unfortunately he also received a copy of the minutes, which disclosed that only 28 members attended, 7 of whom were members of staff, 1 of whom was the warden. And at the time, the number of people who could have come was 745. Things have obviously changed. Justice Wolfe said, if ever there was a practical illustration of the supine condition of a body, this is one. In a matter of life and death, as it was put, only 21 members, apart from staff, show enough interest to come along to the meeting. That being said, he observed in a more constructive vein, in spite of the shortcomings which Convocation has displayed in the past, there should be a large body of constructive thought amongst graduates of the university which, if properly held together, could benefit the university in many ways. In America, associations of alumni do much towards the support of their universities in thought and in deed. I consider it would be a drastic step to wipe out Convocation in its entirety. There is something in what Dr. Somerville says, that Convocation is an anachronism, but the anachronism could be brought up to date. It's a pity not to give an opportunity for thought to well up from the bottom. There was an interesting phenomenon also I should point to, that immediately post-war, of course, there was a generation of students coming back to do servicemen's degrees who already had degrees. And as graduates, they were able to get on to Convocation, which enabled them to become members of Convocation, through Convocation, to stand for election to the University Senate. And the phenomenon is discussed by Professor Fred Alexander in his history campus at Crawley, and there was some complaint that the wrong kind of people were being elected to Convocation. As a student in the 60s, I came across this piece of history, and I was on the Convocation Standing and Statutes Committee as a graduate, and at the time the student perception of Convocation was pretty antediluvian, and there were people who'd been there for a long time, and one of them had been on the Senate, I think, for 36 consecutive years in the interest of continuity. It was a thankless task, and they did a lot of hard work. As a student, I remember writing a piece for Pelican to remind student politicians of the Guild of Undergraduates about the forgotten history of their close connection with Convocation. I did try to make the piece a little more persuasive by trying not to appear a mere apologist for Convocation, so I opened it with a disarming quotation from a 19th century poem about Italy written by Felicia Hemans. The home of arts, where glory's faded smile sheds lingering light o'er many a mouldering pile. Now, my objective was to engage student readers in a serious reflection upon the possibilities of strong relations between the students and the statutory alumni body of the university. But despite the poetic honey trap, I suspect the article was largely unread, probably except by members of Convocation who were probably offended by it. Today, Section 4 of the University Act provides simply that the university consists of a Senate, Convocation, staff and students. And now, however, the Senate alone is the governing authority of the university, as Section 5 tells us. And with the amendments that come into force this year, the Senate will consist of 12 persons with the possibility of co-option of up to another 5. Convocation retains a role in the review of statutes. It can propose amendments. And if the Senate refuses to consider an amendment, to accept an amendment proposed by Convocation, there's a provision for a conference with the warden, and then the Senate can still go ahead and pass the statute without any special majority, although I think it's required to report the matter in the annual report. So Convocation, which was initially a component of the governing authority of the university, enjoys much reduced substantive powers, and in a way, that history rather echoes the history of the Convocation of the Oxford University, to which I referred earlier. Nevertheless, the University of Western Australia Act and the governance institutions it creates continue, like so many of our laws and institutions, to be the vessel of important history which cannot be discarded as simply irrelevant today. It's to be found embedded in Section 3, where you have the reference to the university as a university, and Section 4, which tells us what it consists of. And in that latter description, the reference to Convocation and staff and students, there is the essential element of a community of scholars past and present, a community which extends into the wider society in which the university is embedded. It's a concept which embraces all those who've graduated from the university as well as those who teach, research and study there today. The representative role of Convocation in the Senate, although it's been reduced, and its continuing review function in relation to university statutes, maintains the status of the alumni as a continuing part of the university. Of course, it's up to the alumni to ensure that through activities relevant to the university's mission and through Convocation's own renewal, it does not fall into the category of an anachronism, and certainly the Warden's report suggests that that is nowhere on the horizon. It must be said that the exposition of the idea of the university in the Australian setting is not an uncontested field, and there's been some recent debate about that in the last couple of years, I think, between Glyn Davis and Raymond Gaiter about the notion of the narrative that the universities are somehow in a process of decline. The point away from the original notions of the institutions that they were, and Gaiter suggests that the whole tone of universities has been transformed by the focus on vocational and professional courses. Davis observed that Gaiter's unworldly university as an ideal had always been rare. He correctly observed that professional training dominated Australian universities from their earliest expression, and that can be seen in the history of this university and the things which moved for its establishment. While students enrolled in the liberal arts and academics engaged in public debate had always been important on campus, the dominant tradition had been pragmatic and vocational. What he pointed to was that the changes in funding arrangements, the inability of universities now to rely on public funding and to have to go out into the marketplace means there is now diversity in the strategic choices which universities make, some of them focusing on offshore activities, some of them on onshore activities with different sorts of connections. You can agree or disagree with what he has said in that respect, and others like him, in whole or in part. That does not mean that the core idea of a community of scholars, however varied its realisation may be, should be discarded. That idea, however tenuous it may seem in today's world, can still serve the long-term interests of the university. It says to those who study and work here, as well as those who've done so, that they've not only been engaged in gaining qualifications or making a living as teachers and researchers, they have been and continue to be part of a higher human endeavour, that of the generational transmission of human knowledge and the expansion of its boundaries. It's an endeavour which has deep historical roots, and they should be nourished. The political, economic and regulatory environment may require that the university be a trading and financial corporation, but fidelity to its historical origins and purposes means it should always be able to say that it is considerably more than that. Thank you.
Thank you very much for that address. On behalf of Convocation Council, we'd like to present you with a small token of our esteem, a selection of books on the history of UWA. It looks like you've read most of them already. Again, as we'll have questions as part of the Q&A session, I would ask you to hold your questions on that excellent presentation until then. Item 11 of our agenda relates to other business. I'm aware of 2 items of other business that we wish to consider, but before proceeding with these, I just wish to ask if there are any other items of business of which notice has been given. I'm not aware of any, but if not, I'd like the first item I wish to draw to your attention is the date of our inaugural Convocation Conversations. The title of this event, Reflections on the 2017 State Election, an informed view from Peter Kennedy, I think would be certainly a worthwhile discussion and a very interesting one given Peter's long knowledge and expertise in this section. This will be held on Saturday the 8th of April this year, and full details